Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Joe Bodiford. Joe is a certified criminal trial lawyer. He is also certified in Criminal Trial Advocacy by the National Board of Trial Advocacy. Today we're going to be speaking about motion practice in criminal court. Joe, welcome.
Good morning. Thanks for having me.
Absolutely. What are the most common motions in criminal practice, would you say?
Well, the most common ones probably deal with pretrial detention and pretrial release. Or as I like to say, go to jail, stay in jail, get out of jail. There's processes for each. And all of that revolves around the issue of probable cause. I'd say that the majority of the motions we see are dealing with getting somebody out. A motion for to lower a bond, maybe to change restrictions on somebody's pretrial release. Most recently, I dealt with a young man who was on a GPS monitor, and we couldn't get him into a treatment program because they wouldn't take him in the treatment program with the monitor on. So we have to file a motion to modify the conditions of his release to take the monitor off. So that's the most common.
I would have guessed the most common was a motion to continue.
Yeah, well, probably get a lot of those too. And remember the rule on that, on motions to continue, the rule says they have to be in writing, and most judges will stick to that.
Right. What about any special rules for motions in criminal cases?
Right. 3.190 is our motions rule, and our motions to dismiss come in there. The what we commonly refer to as C4, or as I like to say, the explosive rule, because if you win a C4, you've blown up the other side's case. Very specific requirements of what has to be in there. There's very specific pleading rules. There's very specific answering rules by the state. So once a motion to dismiss is filed, the state can either traverse or demur to it. And then there's issues as to whether there will even be a hearing or not. I also ask everybody to look very carefully at the rules regarding motions to suppress physical evidence and motions to suppress confessions, because the rule does require very specific pleadings, factual, legal, and I've seen plenty of judges over the years take a motion, look at it and go, it's legally insufficient. One judge I knew in Hillsborough County who liked then to take it and throw it in the trash can next to his bench. So you got to be very careful about that, because the last thing you want to do is not do something as simple as reading the rule and complying and be embarrassed in front of your client.
With that, how important is it to know the judicial preference and procedure in your filing of motions in criminal matters?
Incredibly important, and I think your best friend in a criminal proceeding can be the judicial assistant. The judicial assistant not only will coordinate the date, time, hearing, and all that, but can also let you know, this is what Judge so-and-so prefers. He or she likes to have the case law in paper form. He or she doesn't want case law, just send us your motion and he or she will look it up himself. I had one judge that I practiced in front of that liked to have all the cases on a CD in PDF format. So it's really important to know, because when you get to the actual time of the hearing, if you follow judicial preference, then that judge is already well versed in your argument and knows the law and is ready to go.
All right, Joe, thank you so much. That's been great and useful information. And that concludes this video for Mentoring with the Masters. Thank you for watching.